Looks like she's up.
Okay, John Hawley, go ahead and call the meeting to order at 6:32. Roll call.
Steve Ruyle.
Here.
Bruce Savage.
Here.
John Fitzgerald. Chairman Ryan Jones.
Here. Go on to approval of the modified February 7th meetings.
Please correct that one.
Just corrected that one thing, so. the Motion to approve that.
So
Second, all those in favor say aye. Aye. Motion carries. Number 4, comments from citizens. Here with us. New business. We have time extension for Steve Ruyle Sunrise Court file number 2005-01 SUV. Probably should just go right to that one, right?
So this is no reflection on Steve, but I actually think we should not be in favor of it. I think we should do it.
We just had to recuse himself.
Okay, well, I actually think it should be for that. I mean, I think we should actually not be at the table because it implies that you're part of the decision.
Okay, you want me to go sit over there?
Yeah, I mean, that's my, yeah. I know it's optics, but I just think it's important.
The record will show that Steve Ruyle has recused himself and has taken a step off the dais. Back to you, sir.
Do I have paperwork I'm supposed to read on that, or am I, is this just a simple vote?
Ollie, weigh in if you'd like.
Okay, great. I will give a short summary. Good evening. For the record, Holly Byram, Mid-Willamette Valley Council of Governments. So this should look familiar to the Planning Commission. We have a second request for a time extension for a subdivision on Sunrise Court. I think there's a common theme here. You're seeing a lot of your land divisions come in for time extensions. During the pandemic, things are taking longer, material ordering, supplies. And so Mr. Ruyle is requesting a 1-year time extension from July 21st, 2022 to July 21st, 2023. This request was made more than 30 days prior to the expiration, and staff has no concerns. Myself, Public Works, and the city engineer support this time extension request.
So I move that the Planning Commission grant the requested 1-year time extension to subdivision file number 2005-01, moving the final plat recording deadline from July 21, 2022 to July 21, 2023.
Second.
Been moved and seconded. Any further discussion? Seeing none, proceed to vote. All those in favor say aye.
Aye.
Motion carries.
Thank you.
Unanimous.
Where are we going? You can come back.
Let's see. Next up, we have a public hearing for legislative amendment file number 2204-01 LA, a small package of amendments to the Amity Development Code, ADC Proposal 1, ADC 2.206 Stein standards, proposal 2, ADC 1.102.03 violations. Before I get to read this. Ladies and gentlemen, tonight we are holding a public hearing regarding application number 2204-01LA, minor amendments to the Amity Development Code. I now call to order the public hearing. I will now cover the preliminary legal matters. Legal matters, burden of proof, criteria, and appeal rights. The city planner will review the applicable criteria in the following staff report. All testimony and evidence that speakers give us must concern the approval criteria described in the staff report or other criteria of the development code or comprehensive plan that the person testifying believes should apply to the decision. If your testimony should be repetitious, but you would like the opportunity to appeal the decision, you must sign and submit a public testimony sheet before the hearing is closed by the chair. Only those who have appeared before the commission in person or in writing will have standing to appeal this item to the city council. Before the conclusion of the first public evidentiary hearing on this application, any participant may request a continuance or ask that the record be left open to present additional information that is within the scope of the hearing. If there is a request, the decision maker will either continue the public hearing by scheduling a date to finish the hearing, a continuance, or leave the record open for at least 7 days for additional written evidence, argument, or testimony. Failure to raise an issue accompanied by statements or evidence with sufficient detail to give the decision maker and the parties an opportunity to respond to the issue means that no appeal may be made to the State Land Use Board of Appeals based on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient detail to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Before we have the staff report, I will ask a few questions of the members of the commission and then the audience. Does any member of the commission wish to declare a potential or actual conflict of interest or bias? Here's none. Does any member of the audience wish to challenge the jurisdiction of the planning commission to hear this matter? Nope. Does any member of the audience wish to challenge the impartiality or disclosures of any member of the planning commission? Nope. That concludes legal matters. Testimony tonight will be in the following order: presentation of the staff report, second testimonial from proponents, third testimony from opponents, fourth testimony from neutral parties. We'll now proceed to the staff report.
Okay, for the record, Holly Byram with the Mid-Willamette Valley Council of Governments. My role as the contract city planner is to help the Planning Commission understand the criteria they need to consider when they're making decisions on land use applications. This one is a bit of a unique situation. This is a legislative amendment, which means that it was an action initiated by the city of Amity to revise their development code. Those of you on the Planning Commission, most of you will remember we just did a legislative amendment last year. This is another very small package. So a legislative amendment is a type 4 action, which means you have to follow certain procedures to accomplish that. And that includes a Planning Commission public hearing and a City Council public hearing. Your role tonight, Planning Commission, is to make a recommendation to the City Council. The City Council will make the final decision. This is a very small package, just two sections of code are adjusted here. And these are changes that are unrelated to each other, but they both came about recently in City Council discussion. And so we've wrapped them into one package just to get them done. You have to make certain findings when you're changing your development code that tells the state that you've considered the 19 statewide planning goals and then your own comprehensive plan. I've included in the staff report some really brief findings about the planning goals. I'll just touch on the ones that are applicable tonight. Goal 1 is about citizen involvement, and that means that you provided public notice in the newspaper and notice to the Department of Land Conservation and Development, and that you provided these public hearings. So if anyone has questions, comments, or concerns, they can show up and participate. Goal 2 is about the land use planning process, and that just means that you have your adopted procedures that you're following. There are many goals that don't apply to development. So there's 2 different proposed amendments tonight. The first, as you'll remember, we've discussed recently, was about how the city processes code violations and code enforcement. Amity, like most small towns, does not have their own law enforcement officers or code enforcement officers looking for violations. Rather, your budget allows you to be responsive. So when you have a complaint, then you research. The way that you research is that typically your city staff or your deputy will go out and either take pictures or contact the property owner, and then staff will follow up with a letter. And the procedures in your development code were not very thorough, and they were not effective. So Mike Thomas took the lead on drafting new language for that. The other part of the code amendments that are proposed tonight is about temporary signs, specifically political signs. Now, in Oregon and most states, you have to be blind to the actual message on the signs because of free speech. So it's hard to say, oh, this is a real estate sign, this is a political sign, this is a business sign. You can just kind of lump them into categories called temporary signs because they're not mounted in the ground or onto a building. And then you can further divide those by zones. So tonight, you're considering amendments that loosely pertain to economic development and Goal 9. So when businesses invest in Amity, they have a certain expectation that the city will enforce their adopted code. And so that loosely relates to their property values. And then further, with the sign enforcement, you're really balancing a business's ability to advertise or a resident's ability to advertise with not having too much sign clutter in town. So both of these amendments tonight loosely relate to economic development potential in your community. And similar with Goal 10 housing, when residents purchase a property in your community, they have a certain expectation about the quality of housing and just the code enforcement in general. And that is for the appearance of the housing, the function, and the safety of the community. Goal 11 is about public facilities and services, and that relates as well because of the city's ability to provide that code enforcement service. So those are really the only goals that apply to these code amendments tonight. So really brief findings. In the staff report on page 5 of 5 is staff's recommendation, and that is a motion to recommend the council approve these amendments. The amendments themselves are in Exhibit A to Mike's staff report. So if you have those in front of you, I can run through those briefly. In Exhibit A, the first page is just the definition section. The only thing that's proposed to the definition section is to remove the definition of real estate sign, because as I said previously, we have to be blind to the content of the sign. And so that can be removed from the code. On the next page, in section 2.206, that's where our sign code starts. There was an interesting discovery in this discussion that actually back in 2011, there was an ordinance passed with a different set of sign code standards, but we can't determine that it was ever actually enacted or acknowledged by the state. And so that 2011 sign code ordinance here is addressed just to say that that was never officially enacted. So we have to stay with what we've got in our adopted development code until we make additional revisions. On the next page, that's where we really break into the two different kinds of temporary signs. The first category in B is temporary signs in commercial and industrial zones. And then in C is temporary signs in residential zones. So the goal here was to identify how big a sign you can have and for how many days. So B says that if you have a commercial property or an industrial property, you can have a temporary sign up to 32 square feet, or a 4x8 sign, for example, or no more than 120 days in a calendar year or in a 365-day period. No one's going to go out there and count the days to regulate this, but this should be roughly what was allowed previously for several months leading up to a political election. Or you could have a couple months of a political sign and then a few weeks of a yard sale sign. So it's really on the property owner to self-regulate until it becomes a problem and you get a complaint. There is an exception here which describes signs when you have a property that's for sale or for lease, or if it's under construction and you have a contractor sign out front. So there's an exception here that allows for those signs to be posted during that project, and then it's removed either after the sale or the project completion. And this is how the state's template or model code reads, essentially. And then C says that if you're in a residential property, your temporary sign can be no more than 6 square feet in area. So it's a much smaller sign for the similar period, the 120-day period in the 365-day period. And then a similar exemption for houses that are for sale or under construction. In D, we clarified that special districts are included in their exception for governmental authority. And so the reason for that was schools in Amity are zoned residential. And so in this case, your schools will be limited to a 6 square foot sign, which may not work for a number of signs that they may post. Say, for example, they're hiring bus drivers or anything like that. So this grants them a little more authority to post the signs they need to do their job. And then the next piece is about the violation section. So this is section 1.102.03. And this was the new procedural language that the City Council and Mike had generated here. And I don't know if Mike, you would like to jump in here and explain a little bit more about the code enforcement process and how it is on your end.
True, yes, I can do that. We'll back up one more special district that would be allowed would be the fire district. That would also be in that government exemption. That's why we did just state school, we put special district together both. Okay, onward to the enforcement. So what we found with the old ordinance, and if you can read it through the lined out portion, it initially stated that the city could withhold water service to enforce its code violation. Both Bill Monahan, our city attorney, as well as Judge Ross stated that that was not an appropriate process, and you shouldn't withhold water service as part of that. So we found that was an error in our code, so I took this to council as part of a code enforcement on I think I mentioned last meeting, an out of parameters fence. And we had to figure out what the process was. You can also see in the previous text, there was no time limit, no duration, no process for adjudication. So we added all those in, and this was all based off of council guidance. So I eliminated the water restrictions. Now it's withholding of further permits until correction of its construction site, or later it says we can do injunctions, amendments, abatement, liens, etc. I also installed a time limit, which councils wanted us to be 45 days from notification, and or as determined by me, if the perm for corporation or whatever cannot fix the violation. The reason for that is that if the political signs, for instance, would also be under this enforcement if the signs are too big or too whatever. We didn't want to say, okay, you have 45 days, and then by the time the election's over or whatever the purpose is, has already gone out. So I could theoretically state, okay, you got a week to get this done and make it more restrained. Council at the time did not give me any input as to whether they wanted oversight on that. They just said that's up to me. So that's the way why it's written that way. Additionally, we had no enforcement piece. So between Bill Monahan, deputies, and myself, we determined that the Amity Municipal Code 1099 general penalties, which establishes fines and violation dollar amounts and levels, would be the appropriate method for enforcing fines. So that's why that states Amity Municipal Code 1099. Most fines would be approximately, it goes, I think, I don't have it in front of me, but I think it goes 25, 50, 500 to $1,000. And most of these violations would be $25 or $50 additionally. City may, in addition to other remedies, that's the allows us to go in to abate the property if there's a violation for fences or whatever. And the final portion, which was what council asked for too, was a matter for third-party adjudication, which would allow the person to take the matter to the municipal judge and have the matter settled by the judge. And based off of Bill Monahan, we need to give them time to get the information, provide notice, and then put a court date in, which is why you see the 15-day citation date. And then we do have the ability to continue to accrue the fines and penalties until the judge makes a decision, but we understand that the judge could basically, upon his decision, nullify all of them or establish a new set of fines, and that's the requirement. With Bill and Deputy Summers, we determined that a failure to appear basically constitutes like there's a Latin term for it, I don't know, but like basically I'm guilty because I didn't bother to show up. So the full application of the fine and penalties would then be enforced at that point. So those are the changes that we've made. It basically gives a little bit of teeth to our ordinance to allow us in our development code to go out and enforce it for these items. I think that covers everything. I'm open for questions. Holly, unless you want to pick it up from here.
I don't have any further comments. This would be a good time for the Planning Commission to ask any questions they have.
So Holly, the temporary sign, is the 21-day total, has that been in the code already? Or is that something new?
Mike, can I bother you to repeat that? It's a little bit echoey.
He asked if the 120-day total timeline was already in the code somewhere, or if that was something we added or inserted.
And that's similar to what's in the code already.
The code, the Amity sign code, I will state that we had previously, the one that we're nullifying, established a 120 days prior to a public election to 5 days after a public election. I did go through McMinnville's codes. Their political sign code also has about 120-day limit. Their temporary sign code, because they break it out, was also around 120 days. So that was that's where we got the number. Yes, we've inserted it in here, but it was that was where we pulled it from, was from other.
But the 120 days was in even before this revision that we're talking about tonight.
No, not technically. It was not.
Oh, okay.
It was not in there, but where it was located was in this ordinance 626, the City of Amity sign ordinance dated 6 July 2011. The one that Holly mentioned in her report was never officially filed or entered into the system.
Oh, okay.
So
Okay.
I will state that the city not realizing at some point that we had two conflicting codes, have been enforcing both sporadically at different times. And we've been using by de facto standards, the 120-day limit for political signs. So this
Well,
just puts it in
I-
writing.
Yeah, I mean, I will just say that 120 days doesn't seem like a temporary sign to me. But I mean, it's a third of a year. But
The idea being with 120 days would that be basically from a primary to a general election.
okay,
Additionally, I would state that those of you in construction, I believe all of you are, a 32 square foot sign is a sheet of plywood or a ping pong table in size. This was the request of council to make it 32 square feet. I objected to this. McMinnville only allows a 16 square foot sign. Many other communities around here that I looked at are maxed out at about 16, 12, 16. However, if you look at some of the signs that are posted around the county and elsewhere, they are basically about 32 square feet. So that was the intent of council. That's where that number came in. That's why it's 32 feet. The reason it's 6 square feet is we felt it'd be a little ridiculous to have a 32 square foot sign in somebody's front yard that could potentially block the ability of another neighbor to pull out of their driveway or to enjoy their home. So
I think it's worth mentioning Amity's unique situation, and staff talked about this a little bit, and I think we need to discuss it with the Planning Commission. And that is that the corridor along most of Trade Street is zoned commercial, and you have quite a few non-conforming residents there. And we talked about this with our city attorney, and he said, if you're regulating signs, it really needs to be by zone and not what the property is used for. So hypothetically, some of those homes along Trade Street that are zoned commercial could erect a 32 square foot sign on their property. And I don't think that there's much code language that we could look at to change that. So I just wanted to make everyone aware that that could happen.
Any other questions?
I think as a planning commissioner, I'm not interested in giving any input in like fines and stuff. I think that should be up to the city administrator and the council. So I'm not really, I don't have anything to say about the fines one way or the other.
Good.
the only question I had about the fine section was the last sentence on 1.102.03, where it's, and I assume you checked with our lawyer about this, failure to appear constitutes a guilty plea. Is it that our lawyer was okay with that language?
he didn't object to it, but
Okay.
I mean, if you prefer a different, I know you're an attorney, so I know if you prefer a different language, then we can make that change before it goes up to the.
Yeah, actually, I don't know that it would constitute a guilty plea. I mean, someone would forfeit their rights. I mean, I'm not sure what the appropriate language would be, but I mean, certainly, just like if you don't show up for a traffic ticket, you forfeit your rights, but I don't know that you've actually pled guilty.
We can.
I mean, I think it'd be worth checking out to see if there's better language.
What we could do is a failure to appear, cross out constitutes a guilty plea. Just go a failure to approve. A failure to appear approves full application of the fines, penalties, and corrective actions provided herein. So my recommendation, Holly, back me up on this one, is when you make the motion, insert the language that you want that change incorporated. Whoever makes the motion, and then when we'll correct it. Correct me if I'm wrong, Holly, but we would correct it and present it to the council with that change as recommended by the planning commission. If that's that's your choice.
I mean, Holly, do you have some language that you're comfortable with?
This is the purview of the city attorney. This is beyond my forte.
Okay.
I do see your point, but so I think that would be a sufficient correction at that point. Just eliminate that phraseology there.
So that concludes the staff report, I assume.
Yes, sir.
So don't want to public testimony, but there's no public here. No opponents, no opponents. No neutral parties. Next time we want to vote or more discussion.
Is there a need to discuss it at all? I mean, I think it plywood side sign. In the commercial area, it's pretty big. I mean, it seems super excessive. But I don't really understand what we're doing here. So the council is pretty much decided on this. It comes to us for approval.
Well, you can make recommendations for changes, much like Commissioner Savage did, that then I would incorporate, present, and if you all voted to approve those changes, then that would be what was presented as a recommendation from the Planning Commission to council. And it would be up to council to either change it further, accept your changes, deny your changes, or have me basically start over. I think those are the options. So if the Planning Commission feels that a 32 square foot sign is too big and would like to reduce it in size, or I can, again, much like with the other comment, make the necessary changes, and then when you make the motion, you would to approve, or otherwise you would incorporate the said changes. So if the commission wants to discuss and debate that and then make that input, we can do that. Or you can just tell me to change it.
I mean, I'd support recommending a small.
Yeah. How about you guys? You have, yeah, I would go along with that. I mean, 15 square feet, he said that's what Mac has, and that seems
In their commercial district, yes, sir.
more than sufficient.
So are you recommending I change that to 16 feet? Is that okay?
So that's just a recommendation to council, so if they really feel strongly,
They can put it back to 32, yes, sir.
they can.
All right, so we'll make that 16. All right.
I got all my pages mixed up, so I'm not entirely sure where we are. But, there's questions of staff, we've already done that. No one has any more questions of staff, so with that, we'll close the public hearing portion. On to deliberations.
Unless there's anything further that you've done in deliberations, unless you want to address any other aspects of the changes.
Right. You got to humor me, I'm just following my script.
Yes, sir. No, I get that.
All right, so does any member of the commission wish to make a motion?
So I will point out that Holly was very kind to include a formatted motion. I believe it is page 5 of 5. If you have the staff report, my change to this would be if you do do letter A or motion letter A, add a caveat at the very end that says, and direct staff to prepare an enacting ordinance with the planning commission's approved recommended changes or something to set effect, if that's how you want to do that. Otherwise, as and I know I'm stealing Holly's thunder, sorry, Holly, you have 2 other proposed motions in there as well, you can choose from.
So I guess we would go with B. On 5 of 5.
Okay.
I would move to recommend the city council approve the proposed amendments to the Amity Development Code presented in Exhibits A with the modification that staff developed language that would substitute guilty. Substitute guilty for other language that would serve that same purpose. And so that would be the modification of Exhibit A, and the modification for Exhibit B would be to change it from was it 32 square feet
Mhm.
to 16 square feet in under violations page or violations under section B, change from 32 to 16 square feet. No, and those were the two modifications.
Second. Properly moved and seconded. Any further discussion? See the vote. All those in favor say aye.
Aye.
Opposed, same sign. Motion carries.
Thank you for your direction.
This.
We will get those revisions over to City Council for their public hearing on June 1st, I believe it is.
Yes, ma'am.
Sounds good. Do I need to read the rest of this or? No?
Only if you want to thank the audience.
There's no audio. Okay, there's nothing else on the agenda, I believe.
Is this?
Motion to dismiss. Adjourn.
So moved.
We're adjourned at 7:08.
Anything for next month?
Thank you all.
Yeah.
Holly, before you go, you think there'll be anything coming up next month?
There is a chance we will, yes.
Okay.
Spoken from the expert.
What's the date of next month's meeting? The 6th?
Oh, it's not coming.
Second Monday of the month, right? So
The
it's
second Monday? Someone had conflict on that.
13th.
13th.
Yeah, I'm not gonna be around.
Okay.
So Steve can run the meeting.
That won't be around.
We'll plan for June 13th, and then those of you who are not here will just accommodate accordingly. Okay.
Thank you all.
Okay.
Thank you. Good night.
Hi, Holly. And